Good day, everyone. I am Crystal Calbi Malate, and I will going to discuss the the continuation of Chapter 3, Dissolution and Winding Up. So, the following question should be answered. Is the agreement of the partners affecting liquidation valid? What is the meaning of retirement in dissolution? And 3 is the kinds of dissolution that is just an overview of it because it will be discussed by the other reporters separately. So, the liquidation of the asset of the partnership following its dissolution is governed by various provisions of the Civil Code. However, an agreement of the partners, like any other contract, is binding among them and normally takes precedence to the extent applicable the codes of general provision. So, technically, this agreements of the partners is affecting the liquidation and it is valid. So, two, the retirement is a generic sense means that dissociations by a partner inclusive of resignation or withdrawal from the partnership that thereby dissolved is. So when we say dissociation by a partner, it means that each of the partners change their path with each other. So they will retire through resignation or withdrawal. Once they not want it anymore, they can do it because it is by express will, and that partnership is a mutual trust and confidence. So, to further understand the concept of retirement, I will give a scenario. So, A, B, and X. A, B, and X is a partner. So, there are partners. They hired B as the manager of their business. So, on the long run, the partnership cannot shoulder the payment of the employees. That is why si D, kalahati na lang ng salary niya yung nakukuha niya monthly. And hindi din nagtagal, si A and B, nag-decide sila na ibenta na lang kay Y and Z yung yung interest nila sa partnership. So, si X na lang yung remaining na original partner. So, the new partnership was formed and it is composed by X, Y, and Z. Si X yung remaining partner. Si Y and Z yung bagong partner na pinagbentahan ni A and B ng interest nila. So, they decided to continue the employees. They decided to continue the management of the business. So the employees continued the working and then it is they continue the management. So subsequently, si D na-inform na siya na naibenta na nga ni A and B yung interest niya sa partnership wherein na pagdesisyon na ng partnership, ng bagong partnership na hindi na babayaran si D. Hindi na babayaran yung payment na kulang sa salary niya. So, si D, syempre, nag-complain siya for that. He wants to recover yung salary na hindi na niya makukuha. But then, the partnership denied it. So, the following question should be answered. Was the partnership which had hired D extinguished and replaced by a new partnership composed of X, Y, and Z? If indeed a new partnership had come into existence, can D nonetheless assert his rights under his employment contract as against the new partnership? So, going back to Article 1828, says that the dissolution of partnership is the change in the relation of the partners caused by any partner ceasing to be associated in the carrying on the distinguished from the winding up of the business. So, dito, sinasabi na the dissolution of the partnership is the change in the relationship of the partners. So, once there is a change in a relation of the partners, tulad nga ng example ko na si A and B binenta kay Y and Z yung interest nila, there is a change in relationship of the partner. Meaning, may dissolution na mangyayari or na nangyari. So, that the new partner was formed. So, we should take note the Article 1830, which is this is the cause of dissolution in here. So, it will be discussed later on. So, yung acquisition ng interest na binenta ni A and B kay X and Y is coupled as a retirement or withdrawal ng old partners or ni A and B, since there are original partners na nagbenta ng interest, so that yun nga, the new partnership was constituted, and this is the X, Y, and Z partnership. So, the occurrence of events which first precipitate the legal consequence of dissolution of the partnership do not, however, automatically result in the termination of legal personality of the old partnership. So, since sinabi ko din kanina sa example na yung new partnership is kinontinue lang nila yung management and the employees continued working, it means that they simply took over the business na owned ng preceding partnership. So, they did not enter into winding up process of the business. So, when we say winding up, business it is when the business affairs was settled. Meaning, kapag yung mga debts na bayaran na and the credits was collected and also the asset are already liquidated and distributed sa mga parties. That's what we call winding up. So, not only the retiring partners but also the new partnership itself, which continued the business of the old dissolved one, are liable for the debts of the preceding partnership. So, meaning, um, yung bagong partnership is liable na sa old obligation ng old partnership. So, sa example kanina, di ba sinabi na ng hindi na babayaran ng bagong partnership yung balance na payment kay D. So, hindi yun pwede. Kailangan i-shoulder pa nila yun. Kailangan ibabayaran pa nila yun since it is under the article of 1829. On the solution, the partnership is not terminated but continues until the winding up of the partnership affairs is completed. So, ibig sabihin, 'di ba, hangga't hindi pa pumapasok sa or undergo sa winding up process yung partnership, hindi pa tuluyang na-terminate yung obligation ng old partners. So, yung example kanina is all about dissolution or the retirement lang. So, continue na tayo sa kinds of dissolution. It has extrajudicial dissolution and judicial dissolution. When we say extrajudicial dissolution, the partners themselves can dissolve the partnership. Hindi na nila kailangan ng help ng court to dissolve the partnership. So, it is under Article 1830. Yung sinasabi ko kanina na it should be also noted. So, number 1 is without violation of the agreement between the partners, which is it covers 4 scope. So, by the termination of the definite term and particular undertaking. So, kasi specifically the agreement of the partner is to dissolve the partnership after a particular undertaking was accomplished. And also, kapag yung term ng partnership is nag-end na, that is the time na kailangan na talagang ma-end yung partnership, and that is without violation of the agreement because it is naturally happen and it is in the agreement itself. So, by the express will of the any partner who must act in good faith when no definite term or particular undertaking is specified. So, sa 2 is by the express will. So, as we all know naman that partnership is based on mutual trust and confidence. So, meaning, um, hindi mo pwedeng pilitin yung partner mo na magstay pa sa partnership kung hindi niya na gusto. So, once it is felt by your partner na gusto niya nang itigil yung partnership, pwede niya yung gawin as long as it is in a good faith. So, next one is by the express will of all partners who have not assigned their interests or suffered them to be charged for their separate debts either before or after the termination of any specified term or particular undertaking. So, it is the it should be or lahat dapat ng partners is mag-consent sa dissolution. So with that, it is no violation of the agreement. So the last one for the without violation is that by the expulsion of any partner from the business bona fide in accordance with such a power conferred by the agreement. So dito sa D, this expulsion is the right of each partner. They can expel you as long as it is done in a good faith. So, syempre, once na-expel ka, magdi-decrease yung membership sa sa partnership. So, yung decrease or increase sa partnership will cause dissolution. So, 2. In contradiction of agreement between the partners where the circumstances do not permit a dissolution under any other provision of this article by the express will of any partner at any time. So, dito, it is the violation of the agreement. It happens when the situation doesn't permit the dissolution under the provision of 1830. So, even though na the partners can still get out of the partnership since hindi naman pilitan yung partnership. Basta justifiable yung reason and that sinabi ko nga and take note that the withdrawing party will be liable for damages. Third one is by the event of which makes it unlawful for the business for the partnership to be carried on for the member of the carry self. So, unlawfulness of the business. So, dito, ano lang siya. Kapag yung business mo, example, nag-start ka ng business lawful. Hindi siya prohibited. Hindi siya illegal na business in the start. Pero in the long run, magiging illegal siya. Either may napas na batas na nagsasabing illegal na yung business mo. That's the case. 4 is when a specific thing which partner had promised to contribute to the partnership perishes before the delivery, in any case by the loss of the thing, when the partner who contributed it, having reserved the ownership thereof, has only transferred to the partnership the use of enjoyment of the same, but the partnership shall not be dissolved by the loss of the thing when it occurs after the partnership has acquired the ownership thereof. So, nandiyan naman na lahat. Before the delivery, the partnership is dissolved because of lack of contribution. So, after the partnership has acquired the ownership thereof shall not be dissolved by the loss of the thing. So before the loss of the thing, the partnership will be dissolved, and after the loss of the thing, the partnership shall not be dissolved. By the death of any partner, as I was said earlier, na yung decrease sa partnership or yung decrease sa membership ng partnership will result dissolution. So, of course, your partner died and that will less the members. So, 6 is by the insolvency of any partner or of the partnership. So, by the insolvency, um, wherein it can no longer justify or satisfy the obligation, or probably cannot conduct its business. So, insolvency of partner in case of the partnership assets are exhausted, the partner will be liable using their separate property. So, 7, by the civil interdiction of any partner. So, civil interdiction means deprives of the offender during the time of his sentence of the right to manage his property and dispose of such property by any act or any conveyance inter vivos. So, dito, civil debt, the dispose of property by a last will and testament. So, it cannot enter into contract that will dispose his property during his lifetime. So, let's proceed to the judicial dissolution. When we say judicial dissolution, any of the partner can can go to the court to file a complaint or file a dissolution process. So, it is under Article 1831, letter A, on application by or for a partner, the court shall decree dissolution whenever a partner has been declared insane in any judicial proceeding or is shown to be unsound mind. So, syempre, it cannot give valid consent dissolution may be asked from the court. Syempre, once a person is insane, it is incapable. So that is number 2. A partner becomes in any other way incapable performing his part of the partnership contract. Syempre, once a partner is incapable na to perform his duty, maaapektuhan nun yung business. So, you can file it in the court so that the partnership can be dissolved. And yung mga instances na ganun, the partners become incapable is yung mga nagkakasakit, yung mga aalis ng bansa, yung mga ganun. So, number 3, a partner has been guilty for such conduct as tends to affect prejudicially of carrying the business. So, it is the misconduct. So, number 4, partner willfully or persistently commits the breach of the partnership agreement or otherwise who conducts himself in matters relating on the partnership business. This is not reasonably practicable to carry on the business in the partnership with him. So, it is the breach of partnership agreement. So, 5, the business of the partnership can only be carried at loss. So, this is the loss. So, 6 is the other circumstances that the partnership encounter and it can be dissolved. So, that is all I know. There is B. On the application of the purchaser of the partner's interest under. So, the purchaser can can dissolve it after the termination of the specified term of particular undertaking. Sinabi nga kanina na when it's when the term end and the specified or particular undertaking is accomplished, the partnership can be dissolved. So number two is at any time if the partnership was a partnership at will, when the interest was assigned, or when the changing order was issued. So that is all for my report, and thank you. God bless us all.